Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer. I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics. And today we're going to kind of take a break from ag law and ag other risk management issues to kind of talk about, topic that many of us may not, have a lot to deal with in our daily lives, but food trucks. And, what happens with the conflict that will potentially always exist between brick and mortar stores and, food trucks. If you haven't seen it or watched any of the news, there's been kind of a renaissance. I don't know what the exact word would be of, people operating food trucks and creating, interesting dining experiences for people. And these becoming sort of a cultural thing now. And today we're going to look at this from the standpoint of Baltimore City, which had recently imposed restrictions on food trucks that limited food trucks from operating within 300 feet of any retail business establishment that is primarily engaged in selling the same type of food product, other merchandise, or services that was offered by the food truck operator. Food truck operators challenged this law in the circuit court, and that circuit court recently found it was void for vagueness and rejected arguments that the law violated Maryland's Declaration of Rights, protections of due process, and equal protection. So the law is found unconstitutional for being void for vagueness. We're going to talk about what that means because it's kind of an important thing that we need to think about in the law. But at the same time, we'll talk about sort of the other constitutional challenges as well. And what the food truck operators owners did was they challenged this 300-foot restriction on the violation of Maryland's Declaration of Rights. The first challenge was, as I said, was that it violated the due process and equal protection under the law that's guaranteed under the Declaration of Rights. And the second challenge was the one that the court actually did accept in the end, was that the 300-foot restrictions were void for vagueness. And we'll talk about that as we go along. But we're going to first kind of start off with this due process and equal protection discussion. Article 24 of the Declaration of Rights for the state states that no man ought to be taken or imprisoned or disseized of his freehold, liberties, or privileges, or outlawed or exiled, or in any manner destroyed or deprived of his life, liberty, or property, but by the judgment of his peers or by the law of the land. Maryland courts have found this provision to be similar to the due process clause and equal protection clauses that are found in the U.S. Constitution. So those are found in the 4th and 14th Amendments, if our memory serves me right. Now, if I'm wrong, somebody can just point it out to me and mock me for not knowing what I'm supposed to know. But before we get into this, let's talk a little bit about what due process is and what equal protection is. Due process is this idea that it's a safeguard that individuals will not be denied access to life, liberty, and property by the government without some fair judicial process. Equal protection requires that the government must give equal protection under the law to all individuals. It makes sense, right? We can't really take your life, deprive you of liberty, lock you up, or take your property away from you without going through some fair judicial process. Equal protection is the law applies equally to everybody. We don't have different classes that the law protects differently. And when we look at these, both of these have three different standards of review that the court could potentially use in reviewing the law. The first is strict scrutiny. Strict scrutiny is when creates a distinction based on suspect criteria, such as race, or impacts a personal right that has been deemed to be a fundamental right, such as the right to get married, the right to privacy, or the right to have children. The second standard that could potentially be used, and it's what's used for a lot of laws when we look at them, is this idea called rational basis test. And this is a standard used for anything that doesn't impact suspect criteria or a fundamental right. The rational basis test requires that the challenge law must have a rational relationship to a legitimate state interest. But at the same time, there's a third step. There's a third standard that we could use, and this is called a heightened rational basis test. The third standard was developed because courts didn't want to expand what was classified as a fundamental right. But at the same time, it's pretty easy for a government to meet the rational basis test. It's, pretty rare that they fail rational basis, but they do sometimes. But at the same time, if you get to rational basis and you're going to court, more than likely the government's going to win. So courts created this third heightened standard, this heightened rational basis test. And this test was basically applies, let me rephrase that. The heightened basis, rational basis test requires that the statute serve an important government objective and substantially relate to the achievement of that directive. In this case, the court utilizes this heightened rational basis test to review the 300-foot ordinance. The basic idea here was, we were potentially depriving people of their right to participate in an occupation, and the court viewed that as something requiring heightened basis based on previous precedents. And the city points out that the law is to promote the general welfare of Baltimore City by preventing vacant lots, generating revenue through taxes for the city, providing jobs, and promoting real estate investment. At the same time, the food truck operators argue, no, it's none of that. It's just protectionism. It has no legitimate interest. To back up its point, the city called this expert to talk about brick and mortar restaurants naturally engage in competition, and food trucks threaten that competition by pulling customers away. So if we can think about it, we have, two restaurants setting up next door to each other. They may be selling the same thing. They may be selling different things, but naturally they're going to compete with each other. If your restaurant's good, you're going to stay in business. If it's bad, it's going to go out of business. But to the expert, if we have a food truck come in, that food truck could just sit next to a popular restaurant, siphon customers away, run that restaurant out of business, and then leave the area. And that creates harm. This pulling customers away could harm areas with restaurants from a lack of commercial activity and then impact the economy of Baltimore City. So the court looks at this and finds this 300-foot ordinance constitutional under the heightened basis test. To the court, the ordinance protected the contributions made by brick and mortar restaurants, promoted investments, and diversifies the marketplace. The ordinance demonstrated that it was not protectionism and substantially related to achieving those objectives. Now, this part could be appealed and may get reversed on appeal. We don't know yet. We'll talk about why it may get appealed here in a minute. It's only a circuit court ruling, so we still have about 2 other stops along the way potentially to go. The final area that the court looked at was this void for vagueness. Yeah, it didn't violate equal protection and due process, but was the law void for vagueness? The food truck operators argued the 300-foot ordinance was undefined and ambiguous. For a law to be constitutional, typically it's required to inform people falling under what exactly is illegal. If you think about it, you want the law to clearly tell you what's illegal and not sort of, be a wiggle room in it. If you don't know what's illegal, you can't change your actions to conform with the law. So then if the law is unclear, people will be unable to determine if they are subject to the law or even how they could get out of trouble in violating the law. Courts have developed this test to determine if a statute is unconstitutional for vagueness. It requires 2 factors. The statute must satisfy fair notice, and the statute must provide legally fixed standards and adequate guidelines for police, judicial officers, triers of facts, and others whose obligation it is to enforce and apply the law and administer whatever the penalty is. Fair notice allows a person of ordinary intelligence and experience to have a reasonable opportunity to understand what is prohibited and modify behavior according to the new law. Fixed standards, adequate guidelines mean that the law does not give the government too much discretion in determining the law's application. Turning to the 300-foot ordinance, the food truck owners point out that the law states that they cannot operate within 300 foot of a retail business establishment that is primarily engaged in selling the same type of food product, other merchandise, or services that are offered by the food truck owners. To the court, the language primarily engaged in was not something a reasonable person could interpret. The court highlighted testimonies from the food truck owners to kind of show how unclear it was. One food truck owner who sold pizzas occasionally, or sold pizzas and occasionally a meatball sub was on the menu, was unsure if that meant the food truck could even be parked within 300 feet of a Subway store, the fast food sandwich chain, because Subway also sells meatball subs. So the question is, the truck's not primarily engaged in selling pizzas, but occasionally sells a meatball sub. Does that mean it's now limited out of Subway? That was unclear. The other problem with this was the same type of food product was not something that was clear according to court testimony. Testimony from the food truck owners demonstrated that, multiple interpretations existed. They had testimony from multiple food truck owners to show that no one really understood what this law meant. The other question was, how do you measure 300 feet? The food truck operators pointed out how three different entities that could potentially enforce the provision, the police, the health department, and I forget the last one, all had different ways to measure 300 feet. No one was entirely clear on 300 feet. So based on all this, the law was found void for vagueness. What could Baltimore City do? They could go back and clearly define some of this, clearly define how 300 feet will be measured, clearly define a few other things, and this law may not be void for vagueness. The other thing they could do is appeal the ruling to the Court of Special Appeals or to the Court of Appeals, depending on how everything works out. But they do have that ability to appeal the decision, and potentially it could be found constitutional on appeal. It's unclear if that would happen, but they could also go back and rework the law and go back to the drawing board and cure the vagueness issues. These restrictions on food trucks really are a new area of the law. They're slowly areas of the law we've seen develop as popularity of food trucks have arisen. This is not just a Baltimore City thing. We've seen this in other large cities with food trucks. As people begin to look at this alternative dining experience where they can, go get something on a nice day at a food truck and either go back to their office and eat it or go to a park or do something else to eat it. So it's something we need to be aware of and pay attention to. If you're interested in reading the Circuit Court's opinion, I've got a link up to it in the show notes. I've also got a link up to the blog post kind of describing the opinion as well. If you have other ideas for episodes you'd like to hear in the future, please let me know. You can email me at lgoering@umd.edu or tweet me at aglawpaul, and those contact info is all in the show notes as well. Until our next episode, thank you guys for listening and enjoy the rest of your day.